All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so good morning again, everyone. We've got 4 topics that we're going to cover, and 2 of them are very, very closely related. One will be very, very quick, and that's this first one. I just want to comment real quickly that the EEOC Democrat majority remains intact with the chair's Senate reconfirmation yesterday. Charlotte Burrows was reconfirmed by a 51-47 vote. That means the EEOC still has a 3-2 Democrat majority with Chair Burrows being reconfirmed. And what that means is that the EEOC will avoid 2-2 partisan gridlock that existed prior to EEOC Commissioner Kalpana Katagal's confirmation just this past July. And of course, we know the EEOC since July has been very, very active. This is something that I had cautioned our users or our listeners about for many months, that due to the expiration of the EEOC chair's terms, that it would be a while into the Biden administration before the Democrats had a majority. They've had that majority since July, and that remains intact. And that means it's a really good transition into our second topic here. And Tandy, let me ask you a quick question. I've stumped Phil on this one before, so let me see if you can do better than Phil. We've talked a lot on this program about Title VII of the Civil Rights Act of 1964, and that's the primary federal law that prohibits discrimination in the workplace, and also has been interpreted to apply to prohibiting harassment in the workplace. Despite that, what is the one word that actually never appears in Title VII?
All right, you're making me go back to my school days here. So let me think about it. I don't think harassment is in there anywhere.
You just outdid Phil there. The word harassment never appears in Title VII of the Civil Rights Act, and there's never really been any EEOC guidance to employers about how to handle harassment in the workplace. There's been court decisions, but no EEOC guidance. And the EEOC, of course, earlier this year issued its proposed guidance to employers about harassment in the workplace. And they had a comment period that closed yesterday, and they've received nearly 40,000 comments in response to their request for comments about the forthcoming guidance on harassment. And so here are 5 questions that were highlighted that really illustrated sort of the flood of comments that the EEOC is going to have to deal with as they craft their final version of this guidance. The first one is really, really a tough one. And the question deals with how should the final guidance handle misgendering in the workplace? The one way the agencies really tried to take a stand on this issue is by making it very clear that misgendering, which of course is defined by the EEOC as the intentional and repeated use of a name or pronoun that doesn't match the person's gender identity, is a form of illegal sex-based harassment. So although employers must sometimes make religious accommodations for employees with sincerely held religious beliefs, those accommodations don't include allowing the religious employee to create a hostile work environment for an LGBTQIA+ colleague, according to the EEOC's guidance. Now, of course, there's 2 sides to this. The proposed guidelines regarding misgendering were really a focal point of thousands of submissions. Supporters of the EEOC's position on misgendering said protecting people from transphobia is both laudable and necessary under anti-discrimination laws, while critics have asserted that what the commission proposed would violate religious and free speech rights under the First Amendment. And that would be free speech is easy to understand. I'm sorry, religious, it would be easier to understand. Free speech rights, that gets implicated because now you have the government stepping in and telling people what kind of pronouns they have to use when referring to other people. So they would argue that that's an impingement on their First Amendment right to free speech. So that's going to be really, really interesting to see how that one shakes out. And no matter what the EEOC guidance says, my hunch is that one way or another, that is going to end up in court. The next one is how
Bert, I
should,
have a question.
of course,
Bert,
go
I'm
ahead.
sorry. I have a question about that because the standing guidance from the OFCCP on affirmative action right now is that employers are supposed to make a visual determination if they don't have information on the gender of their employees when they file their AAT report. These feel in conflict. What advice would you give employers that perhaps don't have that information, or an employee refuses, or it doesn't fall into a binary category?
Yeah, I think again that the EEOC's guidance that they're looking at issuing specifically deals with misgendering, and their definition is very important there because it's defined by the EEOC as the intentional and repeated use of a name or pronoun that does not match. And so that means that an employee comes up to you or says that I want to be referred to as a particular gender, and then continuing to refer to that employee by their birth gender would be in violation of the EEOC's guidance. So I think the two concepts, while related, really are analyzed differently, but very fair question.
Okay, thank you.
Sure. So the next one is that the EEOC is really going to be wrestling with. A ton of comments came in on this one as well. And that had to do with how should comments from abortion foes get addressed in the workplace. We all know that earlier this year, the Pregnant Workers Fairness Act went into effect. That law requires employers to offer accommodations to workers who are pregnant or have a condition related to pregnancy or childbirth. And those regulations, which will be finalized by the year end, the EEOC has stated that a person's choice to have or not to have an abortion falls under that law. And so in the harassment context, the EEOC has taken a similar position, saying that unlawful sex-based harassment includes hostility that arises out of a person's reproductive decisions, including abortions or contraceptives. So again, a ton of comments came in on that one. The last three, I'm just going to name them real quickly. Should the final guidance specifically address domestic violence? Another one is, should employers be given more clarity on the interplay between Title VII and labor law? And then finally, should more light be shed on online harassment? So that's what the EEOC, that the bulk of the comments that came into the EEOC, the 40,000 comments related to those topics. All right, so I want to shift gears for a second. I want to talk about and kind of get back to what Nick was saying before, that when I started Lawyer on the Clock today, that this was going to be a quick section of self-affirmation, and I told you all that you all have no idea, but here we go. So yesterday, the Missouri Supreme Court issued a decision in the case of Brown versus Go Jet Airlines. Go Jet Airlines is a regional jet carrier for the mainline characters. They happen to be based here in St. Louis. And the plaintiff Brown in that case brought a purported class action lawsuit for breach of contract, saying the employer Go Jet Airlines violated a bonus agreement that it had entered into with its pilots. The airline Go Jet attempted to force the matter into arbitration because they argued that they had a binding arbitration agreement with its pilots. The trial court initially ruled that the arbitration agreement was invalid. The case went up on appeal. That court decision was affirmed 3-0 by the appellate court. And then that case went all the way to the Missouri Supreme Court. And the Missouri Supreme Court, like I said, just yesterday issued a unanimous decision saying that the arbitration agreement in the case is valid, and therefore the case must be arbitrated instead of tried in court. Now, there will be some other issues in this case that an arbitrator will have to decide regarding the validity of the agreement, the enforceability of the agreement. But as for the validity of the agreement, the Supreme Court decided that the arbitration agreement was valid. And, I'm covering this case again because it just so happens that the airline's attorney in this case was represented by yours truly and two other great attorneys from my law firm, Heidi Durr and Madeline Brown. And like I said, we prevailed on this case that we argued about 2 months ago.
I was going to say, Burt, for those of us listening to the show, we know this is another W in the column, right? So you're got to be feeling really good about that.
I am. This was a big deal, and really happy about the result of the case. All right, and then the last one we'll have a little. Thank you. The last one we'll have a little bit of fun with. I got one word for you, Tanya. Tanya, guess what I'm going to say here?
How would I know with you? Right. I'll never know, right?
Yep. This one's going to, excuse me, this one's going to come out of left field. Mocktails. Mocktails. So,
nice.
Yeah, so this mocktails are being advocated this year as a key ingredient for holiday party inclusivity. And of course, we know the holiday season's approaching and companies start to organize year-end gatherings. Many experts that are out there are saying that featuring mocktails to accommodate non-drinkers and cut down on the potential for bad alcohol-fueled behavior is a really good idea this season. So just take that into account as you all are planning your holiday parties. Mocktails may be a useful thing out there.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.